I'm Rilus an estate attorney here in Arizona. In the next few minutes, I'll show you, in plain English, the difference between a trust and probate, the ways an estate can skip court completely, and how to tell which one applies to your family. And I'll let you in on the secret early. It almost always comes down to one thing: how the assets are titled. First, what probate actually is. Probate is the court process for settling an estate, proving the will, officially appointing someone to act, and authorizing them to transfer assets. It's public, it takes months, and in Arizona, it's usually not as scary as people fear, but it's still court. What a trust is supposed to do. A living trust is built to avoid probate. If your parents' assets are owned by the trust, the successor trustee can step in and transfer them privately. No court, no public filing, that's the whole appeal. Here's the part that surprises people. A trust only controls assets that were actually retitled into it, what we call funding the trust. If your parents set up a trust but left a bank account or a house in their own name, that asset can still need probate. The trust document alone isn't enough. The title has to match. Some assets skip probate no matter what. Regardless of a trust, certain assets pass automatically. Anything owned jointly with rights of survivorship, and anything with a named beneficiary. Life insurance, retirement accounts, payable on death, or transfer on death accounts. Those go straight to the named person. The pour-over will. Most trust plans include one. It catches anything left out of the trust and pours it back in, but to do that, it may still have to go through probate. If the leftover assets are large enough to trigger probate, the safety net can work if the assets are small enough, but sometimes it still requires probate. Arizona's middle path. Small estate affidavits. For smaller estates, Arizona lets you skip full probate with an affidavit. For personal property like bank accounts, vehicles, and stock, you can use a small estate affidavit if the total is under $200,000 after a 30-day wait. For real estate, there's a separate affidavit for up to $300,000 in equity after a 6-month wait. No courtroom, just paperwork. So, do you actually need court? Put it together and the answer is usually clear. Assets in the trust, trustee handles it, no court. Joint or beneficiary assets pass automatically. Small estates under the limits, an affidavit. Anything left over and large enough, that's when probate comes in. And which bucket you're in comes straight back to how each asset is titled, exactly what we talked about in the first video. You don't have to diagnose this alone. The good news is, figuring out which path you're on is usually a quick answer once someone looks at the titling. That's the first thing we sort out for families. If you're in Arizona or California and you're settling a parent's estate, call us anytime at 480-470-1422. Our virtual assistant Grace can take down your situation 24/7, and a real person from our team will follow up to tell you which path you're on. I'm Rilus with Rilus Law. Thanks for watching.